Hi everybody, and welcome to Couch Counsel, a Hirschler video series focused on legal issues and bankruptcy concerns during these rather unprecedented times. I'm Larry Katz, bankruptcy and creditors' rights attorney with Hirschler, and I'm joined today by my partner, Kristen. We both work out of the firm's Tysons corner office in Northern Virginia. This is part of a series of presentations exploring business bankruptcies and other forms of restructurings and wind downs. Today, we touch upon landlord-tenant matters. Seems like every other day, another chain of clothing store, restaurant, health club is filing for Chapter 11 bankruptcy. What do all these bankruptcy filings have in common? Leases. Kristen, what do you do if you're a commercial landlord? One of your tenants is J. Crew or Pier 1 or Ann Taylor or any one of these other major retail chains that have filed for bankruptcy recently in Virginia.
Well, Larry, what we're seeing with these big retail bankruptcy cases is that things move really, really quickly. And so if you're a landlord and you have one of these retailers as a tenant, or a retailer that you've heard in the news might be heading towards bankruptcy, you really need to be on your toes and be looking out for a bankruptcy filing and potentially what is going to happen to your lease. In bankruptcy, there are three different things that a landlord can do with a lease. They can assume the lease, which means the lease just goes on as it is, uninterrupted. They can assume an assigned lease, which means, again, the lease goes on uninterrupted, but they assign it to a third party. And this is typically used in a situation where they're selling the business. A new owner is coming in, they're going to assign the lease to the owner. Or they can reject the lease, and that basically means they breach the lease effective as of a date approved by the court and the lease is terminated. What we're seeing in the big cases is that the retailers are rejecting a lot of leases so that they can shed some of their retail space, and that's happening within the first couple of days of the bankruptcy. So landlords really need to be on the lookout.
So your tenant then has three options when it files for bankruptcy. It can assume and assign, or it can reject the lease.
Right.
Each of those may give rise to different types of monetary claims that you as the landlord will need to assert in the case in order to protect your rights. Well, Kristen, what if you're not the landlord in the case? What if you are a tenant and you learn that your landlord has filed for bankruptcy?
Well, it's very similar to if the tenant had filed for bankruptcy. You have the same three options. Your lease can be assumed and assigned, or it can be rejected. The big difference, however, is if the lease is rejected, you as the tenant do not have to move out. However, the landlord does not have to continue to offer services that it might otherwise be obligated to offer under the lease. So for example, if you have snow removal services or ground maintenance services, your landlord might not do that for you anymore if you elect to stay in the space. One other thing I would note, Larry, is sometimes the landlord is actually not the ultimate owner of the property. The landlord is sometimes leasing the property from another entity, and the tenant is really a sublessee. And those cases get even more complicated.
Well, that would make the case more complicated. Whether you're the landlord or the tenant, if the other party to the lease files for bankruptcy, it's essential that you know what your rights are and that you act quickly to protect those rights. You have to understand what actions could be taken in the bankruptcy case with respect to your lease and what your own options are. And you need to know whether or not you may need to file a proof of claim in the bankruptcy case, which is something that we're going to be discussing in another Couch Counsel presentation.
That's right, Larry. That's in an episode coming up. We'll be talking about proofs of claim. I appreciate your time today, talking about landlord-tenant matters in bankruptcy. And we appreciate everybody joining us for this session. Thank you.
Thank you.